The next case on the docket this morning is case 53, Torney versus Towson University. When the tables are clear, counsel, please approach. Mr. Cammarata, when you're ready.
Good morning. My name is Joseph Cammarata. Along with my co-counsel Stephen Aller, we represent Ms. Torney. Let me first thank each and every one of you for your willingness to hear this case today. We do appreciate it. I'd like to focus on what the question presented is in this case, because I think it serves as the underpinning for going forward. And that is, did the appellate court err in its description and application of Maryland law regarding a landowner's duty to protect an invitee from a shooting on the landowner's property? The short answer is we think the court did err. But the important point that I want to mention is about the status between Ms. Torney and the university. We maintain that throughout this litigation, from the trial court all the way to the answer to the petition for certiorari, that the status of Ms. Torney was not in question. As a matter of fact, the only issue that was presented was whether what duty was owed and whether or not it was foreseeable that the harm that befell Ms. Torney was within the scope of the duty that the university owed to an invitee.
So I understand the question presented, but at the end of the day, aren't we really looking at whether the circuit court erred in granting a motion to dismiss?
Yes. However, we have to take the record as we have it throughout this litigation, and what we can now discern, we can attempt to litigate the issue of, was she a bear licensee, was she a trespasser, was she an invitee, was she something else? The point I'm trying to make is that the status and the analysis that we need to do is, what is the duty of the university to an invitee?
But what if, so the question before us is whether really, I think, the trial court erred as a matter of law granting a motion to dismiss. I mean, we can focus on what the appellate court did, but at bottom, we're trying to figure out whether this case should go forward, and a circuit court has decided as a matter of law that it should not. So it seems to me that we are addressing a legal issue about whether the circuit court erred in granting a motion to dismiss.
There has to be a predicate for the basis for its ruling, and the predicate was that Ms. Torney was an invitee. Both parties had represented to the court, had litigated, had briefed that issue, and that was the underpinning, the foundational element that led the court to say that based on the allegations and the pleadings, it wasn't sufficiently foreseeable for the university to make a determination that a gun would be used in that pop-up party that was held at the common area of the university. And so the analysis was, and both parties had identified her status as an invitee.
They hadn't identified her status. I mean, as I understand it, it was sort of assumed. Like we're willing to assume for the sake of argument in order to get to this other issue of the duty that she was an invitee. They didn't agree she was an invitee.
Right. No. Yes, everybody assumed it. They could have argued it as some other way. But now, at the Supreme Court, for the first time, we're hearing that somehow Ms. Torney is a bear licensee. That's not right. It's not fair.
Let's assume that she's an invitee.
Okay.
What's your argument?
My argument is this, that there was a duty that the university owed to Ms. Torney to protect her from foreseeable harm at the hands of a third party.
Let's go. We'll have plenty of time to get to that, but on this invitee issue, let's say we agree with you here, and we send the case back for discovery. Is her status as an invitee locked in for all time in this case afterwards, or at summary judgment, could there be an argument that, based on the discovery, that she's something other than an invitee?
I can understand where Your Honor is going, but let me answer it this way. If there was any unclarity, that's not the right word, but if there was any confusion as to her status, we would ask the court for leave to amend the complaint because she is an invitee.
By virtue of what?
And we can make that, excuse me?
By virtue of what?
Who she was to that university.
Student?
Excuse me?
Was she a student?
She was a student, yes, and she had a right to be on the campus.
Okay, is there a difference between, sure, but is there a difference between if she was walking home from class or walking home from, she's studying late at night at 11:30 and walking home from the library, and versus coming to what the plaintiff pleaded was a unscheduled event?
Unsanctioned
I
party,
think it's called unscheduled in the complaint.
or a pop-up party.
Is there a difference in what the duty is owed to it?
No, she's in a common area. If she was, there is the case, I believe the case.
So she's on the common area for an event that violates the school's policies, that goes against, she's not permitted, she's not supposed to be using the premises for that purpose at that time. She still maintains the same status as if she were walking home from the library.
Yes, she's in a common area, and there is a duty to protect her within a common area. If she had been in her dorm room and something happened, that's a different story, and I think that's the Rainey case, as I recall, that the court said there is no such duty, even though the fact that individual was a student. Here she's a student, she's in a common area. The university knows that these events happen. They're pop-up parties. In fact, one happened earlier, and the police then were told to stand down by the university president and the chief of police. And they were told to stand down with respect to this pop-up party.
So a bear licensee in the case that we just decided last year is described as one who enters property with the possessor's permission, but for her own purposes. How is she not a bear licensee when she's attending an unsanctioned pop-up party at 11:30 at night?
Well, I think that the indicia with respect to the mutual benefit for one, it creates a status that is not a bear licensee, but one of an invitee.
What is the mutual benefit to the university for students attending something that is unauthorized on campus?
Well, something that they acquiesce in becomes authorized. And here, in fact, the benefit is she's a student, she's getting to enjoy college life. The promotion of the university is that we want people to come to our university and to be well-rounded academically and socially and otherwise.
I hope Towson has better selling points than that.
Excuse me, Your Honor? I didn't hear you.
I said, I hope the university has better selling points and come to our university so you can come to pop-up parties that aren't permitted at 11:30 at night.
I'm not in the PR business, I'll tell you that. So I probably there's a better articulation as to why, and it's on the website, and I don't have it at mind.
But your point is, social aspects of college life is a feature of a university, whether it's a sanctioned fraternity party, sorority party, or in this case, the university knew about a pop-up party. It's part of modern-day college campus life, and the university acquiesced to it. Is that your point?
It is. Thank you, Your Honor. It is.
Before we get too far, I just want to make sure I understand your response to Justice B. Ron's question. He asked whether you were taking the position that if we send this case down, that basically the issue of her status is foreclosed thereafter, that meaning a decision that she's an invitee. You started talking about amending your complaint, which I take to be an answer that no, the status issue would not be foreclosed from being raised. It would still be a question that could be open in the litigation in the circuit court. Is that right?
Frankly, I'm not sure if it could be, if it's foreclosed. But I was hedging my bets, if you would, that if in fact it's not foreclosed, I still would have the opportunity to amend the complaint. And because or I can get admissions from the university that would.
Well, let me ask it a little differently. How could it possibly be foreclosed when the motion to dismiss was brought saying, just, we'll assume for purposes of the argument that she was an invitee and it was litigated on that basis. How could that possibly lead to foreclosing the issue and that be a final determination that she wasn't an invitee just because people assumed that for the sake of argument?
I understand, Your Honor, and what I'm saying is that I think that even if it wasn't foreclosed, it will be foreclosed. I don't think that her status as an invitee. I think that where we really are is that the university wants to change the definition of foreseeability. They want to eliminate the for, F-O-R-E, and make it just seeability. They just want to, if we could see it, if we could see the gun, if we could, if we hear it, we hear somebody telling us there's a gun, or we hear a threat of violence, well then, we have a duty to act. But since that didn't happen here, we have no duty to act, and so we were surprised, and therefore, we have no liability to Ms. Torney.
So what duty does, back to what I asked a while ago, what duty does the university have to assume for the sake of this argument for an invitee to protect her against foreseeable harm?
Well, the duty that the university has is to protect her from risks arising from the acts of third persons, which the university knew or had reason to know were occurring or about to occur. And the case of Sherman is the one where that if the harm is within the general field of danger, which should have been anticipated, then there was an obligation, a duty to act. Here, not only was the harm...
Is that a question of fact or a question of law?
That's a point that we make in our brief. I think that's a question of fact.
Aren't you asking us to decide
Excuse me?
a societal policy question of whether it's within the general field of danger when you enter into a large crowd that you're going to be shot by a third party? And isn't that what the Taco Bell case and the 4-3 case in Colorado decided? But they decided that as a matter of law and a matter of policy.
If in fact reasonable minds cannot differ on the question of foreseeability, and if you take it from that perspective, Your Honor, I would agree, then it becomes a matter of law as to whether or not gun violence, and why I think this is an important case in the sense that are guns to be treated differently? Well, if it was a bottle or a knife or a fist or a rock, oh, that's okay. We understand that's within the scope of a general field of danger. But guns, that's different.
What if she was trampled?
Excuse me?
What if there was a melee at this pop-up party and she was trampled and was injured?
Trampled, still within the general field of danger. Their point is that the university's point is if we didn't see it, we didn't hear it, we have no liability. That's not the rule. That's not what our case, what the cases in this jurisdiction hold. It's broader than that. It's what's can be reasonably anticipated under the facts and circumstances. We don't divorce ourselves from the facts and circumstances that exist at that given moment. And let's take a second back. I need to mention the facts of this case because they're important. First of all, as I mentioned, the university president and the chief of police said, we're going to stand down. Just watch, okay? If something happens, watch until something happens.
The issue of liability.
Excuse me?
That all goes to the issue of liability, not to the, or breach of a standard of care. It doesn't go to the issue of duty.
It creates an environment by which they were approaching what they needed to do, okay? They had blinders on. But let me get to the, if I may, get to the, I want to address what you're saying, but I want to get to the particulars. These 4 campus police are asked to go to this event to watch. They're watching. They see that the event starts, when they get there, it's approximately 100 students or so. Within an hour, it moves up to 400 people, 400 individuals. Now they're sitting back, and there's underage drinking, there's pot smoking, there's music blaring, people standing on pillars, money being thrown in
But
the...
you almost seem to be putting the university in a can't-win situation. They've said from the outset, this is an unsanctioned event. We don't want students to use this space for these purposes. And then if we provide some law enforcement to observe what's going on, you seem to be saying that that in and of itself creates a duty to anyone there who happens to be harmed as a result of a third party taking action against them. So how can the university protect itself against liability if even for an unsanctioned event that students are told, don't do this? How are they ever going to be able, how will the university ever be able to claim there is no duty?
I don't think they'll ever be able to claim there's no duty. I think that they have to claim there is a duty. There is a duty to act. They acquiesced. They did it once. Now they're doing it again. They put people on the ground, and they sit and they watch. They themselves, how they can act to protect themselves, presence, the continuum of force pyramid, if you would, presence at the minimum level, it leads to deterrence. And
But aren't you saying, like little Mary had her teeth chipped out in Sherman when the teacher left like little Mary had her teeth chipped when she left the classroom? Aren't you saying that the test is whether the actual harm was in this general field of danger, the general zone of danger? And it should have been anticipated something was going to happen at a pop-up party at 1:30 in the morning with 400 kids, music blaring and things like that. The actual mechanism of harm, what exactly happened, whether she was trampled, whether she was stabbed, whether she was intoxicated and fell and hit her head, whether she was shot, whatever it is that doesn't matter with respect to the duty. Is that what you're saying?
that's exactly what I'm saying. Yes, thank you.
So you're asking us, basically, I think in your brief, this is something we should reasonably anticipate in the setting of modern life. So what I think you're asking the court to hold is that it's foreseeable that you're going to get shot if you go to a large event. That's a foreseeable thing where a landowner has a duty to protect you.
That's one mechanism of injury. And as His Honor has just mentioned, and the case law segment says, so long as it's within the general field of danger, that the harm can be reasonably anticipated, should be anticipated. And we don't carve out the precise hazard or the mechanism. We don't treat guns separately. Oh, that we can understand being trampled and using a bottle and using a knife. That's why they have venues. They don't have bottles anymore. They're going to use plastic cups. Guns are not so foreign that we should say, we can't even imagine that this is in the general field of danger. Of course it is. Of course it is. And so we need to do something. We just can't say we're going to lay back and we're going to pretend that guns are something different. We want to pretend and forget about gun violence and how it is rampant within our society, and that somehow that isn't a foreseeable hazard. Oh, yes, it is. It's within the general field of danger. Seligman talks about the McLeod case where a girl is left with two boys. The teacher goes away, and the two boys take this little girl, and they bring her under the bleachers, and they rape her. Now, that was found, and the court recognized and acknowledged in Seligman that was within the general field of danger. And I don't think it's a big leap, a big stretch to say that use of a gun is something that is within the contemplation that there may be harm.
Let's
here
say
was
that
for.
we agree with you on that point, though, Mr. Cammarata. Let's say we agree with you on that point.
Okay.
Guns are prevalent, guns are, lead to untold violence. But here, it's an unsanctioned pop-up party. It could be some other type of weapon. How does that get you past the duty stage?
We're focused on the unsanctioned. Well, shut it down. If it's unsanctioned, close it, stop it.
So on the one hand, you're saying that there's a mutual benefit for these pop-up parties in that she attended, her attendance had a benefited her and benefited the university, and the university had a duty to shut it down.
As an invitee, they had a duty to shut it down.
Because
That's
it's
right.
a loud crowd, and it
No, not
seems
just-
like it's getting out of control.
Not just because, well,
If
the
the
po-
Preakness gets out of control in the infield, is there a duty to shut it down because it's loud?
there's a
and
duty to do
boisterous?
something, not just stand and watch it. As a matter of fact, 2 of the police officers said to the chief, shut it down. Shut it down. And the DJ, who has no training at all, stopped the music and tried to restore order. The DJ. If the DJ could figure it out, you would think the 2 police officers could figure it out. And I just want to make one last point. I want to save my last couple of minutes for rebuttal. At the end of the day, the university investigated this incident, and the corporal that was in charge, Shanahan, she was suspended. Why? Because for among the reasons, the 2 that are important to me anyway, are that she had the ability to contact Baltimore County for assistance. She knew ahead of time, and she didn't do it. That was number 1. Number 2, they suspended her because she had failed to act, to do something to intervene, to prevent what we have. That's in the complaint.
Does it matter when a duty arises then under your scenario? Let's say that the officers that were there, the security that was there, said, we're shutting this down, and as people are then leaving, then Ms. Forney gets harmed. Does the duty arise?
There's a duty. They're acting, and then the question then would become a factual question, I would think. Did they do it in a reasonable fashion? And let's assume that they were doing it, and they had the appropriate number of officers, they were doing it in an orderly fashion, and somehow something happened. I think that's a harder question that in terms of the obligation, the liability of the university under those circumstances. But sitting back, watching this event go from 100 to 400, underage drinking, pot smoking, DJ stopping the party to try to restore order, 2 of the police officers saying, hey, we better do something, we got to stop this thing. Don't worry about it. And now, that's where we are. Thank you.
Okay, Mr. Cammarata, you'll have just over 8 minutes for rebuttal, and Mr. Dietrich, we'll hear from you.
May it please the court. This case asks this court to determine the tort liability of a public university when a person is injured by the criminal act of a third person at an unsanctioned party that just happens to occur on the university's campus. And because this party in this case was unsanctioned, Ms. Torney and all the other attendees were not invitees of the university, but rather bare licensees to which a lower standard of care is due.
If she had been walking home from the library at 11:30, just on the way to the dorm and just passed through the party and was shot then, would she be an invitee or a licensee?
I think at that point, once she's an attendee of the party, she is a bare licensee because she is now participating in the activity.
What if she just has to go through, what if to go from the library to her dorm, there's no way of avoiding it, and that's all she's doing?
I think at that point, she may be an invitee. I don't think there's a question.
This case may be very different from a duty standpoint. To a student, let's say the library closes at 11:25 and leaves and walking back to the dorm.
I think there are 1,000 questions that could be asked along those veins. And they go from the spectrum of she went there, she was lawfully attending, as opposing counsel says, this party, she was an attendee. There's no other.
So there's 1,000 questions, so why are we dismissing the case on the pleadings?
Because we only need to focus on one question, but hypothetically, was she at the dining hall during normal business hours? She's probably an invitee. Was she at a Towson Tigers basketball game on campus?
But if we don't know what her status is, then how are we dismissing this case based on the bare allegation of the complaint?
Because the bare allegations show that she was an attendee at this party and for no other purpose. That's why she was there. There's no dispute about that. There's no dispute about a material fact about why she was there. She was attending this pop-up party, this unsanctioned party. She arrived at around 11:30, I think is in the record, and she was there at around 2 a.m. when the shooting occurred.
Mr. Cammarata, I think, if I understood his answer and to my question and the chief's follow-up, has acknowledged that it's not set in stone as the case proceeds that she's an invitee, and you, up till now, have assumed for purposes of argument that she is an invitee. So why are we talking about it now as opposed to if we otherwise send this case back, make a record later on that she's a licensee and ask for summary judgment on that?
I mean, I agree that the status is not set in stone, so it could go back, it could be litigated. But on the complaint, there's no dispute of why she was there, and the sole purpose of why she was there was to attend this party. And the reason, and I understand, at the motion to dismiss stage, you raise a claim. We stand fully behind our position all along that no duty is owed because there was no harm that was foreseeable, that was reasonably foreseeable in this case. But I think we're here at the Supreme Court. We're here contextualizing this case, announcing a decision based on these facts. But the other thing,
clarification, but the ACM and the circuit court made the decision based on the premise that she was an invitee, right?
that's correct, and I think you know this, but we never conceded. We just assumed for argument's sake that was the case. But when you get into all of these cases, that are being analyzed here, all of them are contextualized by invitee, clear invitee status, where someone is invited, whether it's a business that invites someone to be on the premises, whether it's a bar that invites people, encourages people to come there to get that mutual benefit. Whereas here you don't have that. You have an unsanctioned party, and as we've been discussing today, the university, even if they necessarily acquiesced in those people being there, did not want them there, did not invite them there, did not induce them to be there.
How can you say that if they acquiesced to it? If they knew about it, they have a police force, they have officers there. They could have said, oh, a pop-up party is tonight, let's break it up.
They could have, and they could have exercised their discretion.
So anything that happens, they didn't do that. So anything that happens after that, it's, well, tough luck on the people who are there. So if she drank, like all the other parade of horribles, if she trampled, if she fell because of intoxication on school grounds, which presumably the police department, the university police is supposed to, law and order, they're supposed to prevent that stuff. If any manner of mechanism harm occurred to her, or anybody for that matter, when they attend a pop-up party that's unsanctioned but acquiesced to and allowed, your position is that, well, they're out of luck.
But that's the nature of the case law. I mean, that's the nature of the restatement that talks about bare licensees, as it very clearly can state that.
Well, I thought we're premising this on the fact that she's an invitee.
Oh, if that's the case, then there was no indication of all of those parade of horribles being imminent or impending.
But the police were there then, right? I mean, they didn't just say, well, this is not a matter for us. This is not our concern. They go to the party, and I mean, how is that not like strong evidence of the fact that they thought they had a duty to do something? We could argue about whether the other elements of negligence were met down the road, but I mean, it's not like they said, it's unsanctioned, it's not a matter for us to even worry about.
But I think what's at issue here is a tort duty, and whether the police have some other moral duty or some sort of duty that we would ascribe, but this court's rejected that in the nature of the public duty doctrine. So I think that's one of the contexts that at play here, is that we're not asking what did the owner of a convenience store do or what did the owner of a bar do. We're asking what did police officers who are trained and who have discretion to say, an unsanctioned event is occurring, it's this status at this time, what are the pros and cons of shutting it down, or shutting it down, what are the pros and cons of letting it go?
Where in the record is that the police consider the status of the people who are at the pop-up party?
Well, I don't think they would necessarily.
I mean, you seem to be, conflating two different things. I would like you to stick with the premise that the ACM and the circuit court ruled on, is that she was an invitee. It might very well be she wasn't. And then I guess on summary judgment, that'll come up again. But right now, they dismissed the complaint based on the presumption that she was an invitee.
Right, and if her status is not at issue in this case, whether directly or indirectly, I believe this is a extremely very straightforward case. And in fact, my presentation would be essentially wrapped up in one sentence, and that would be because there was no indication that they knew that anybody at the party was armed, that there was
no
indication.
Indication in Sacrament that when the teacher left the classroom for 30 seconds, that little Mary Jean was going to get her teeth kicked out. But so it wasn't the actual, we can't predict what bad thing is going to happen when you allow a pop-up party or when a teacher leaves a classroom for 30 seconds. We can't predict it. The question is, did she have a duty to keep those folks safe? Did the university have a duty to make sure that that this pop-up party didn't get out of control? We can't predict whether someone's going to be trampled, someone's going to be stabbed, some young undergrad is going to drink and fall and hit her head, or worse, some kind of a sexual assault. We don't know. We're not clairvoyant. We don't know what's going to happen. We just know when we get 400 kids smoking marijuana and drinking that loud music, something good, something bad, I should say, something bad might happen.
Right, but if that's the case, I think you've basically placed a strict liability label or concept on the university.
Negligence. I mean, then we look at after the duty, then there was a breach, was it proximate causation, were there damages? I mean, all the other aspects of negligence kicks in. But I mean, I take the university position is that they owe no duty to invitee for anything when they show up at a pop-up party at 1:30 in the morning. That's unsanctioned, but even though they knew about it, even though they have police force, even though, they had a duty to break it up.
Well, I would just push back on that. They owe them a duty. If they are invitees, they owe them a duty. They owe them a duty to protect them from reasonably foreseeable harms. And where there's a party, just drinking, smoking cannabis, loud music, all of those things do not give any indication that anyone is armed or that any violence is impending or imminent such that there's a duty to intervene.
What if there's just a fist fight and a person gets knocked out and hits their head and is really injured?
I think if they are invitees, then there would be a duty to intervene once the...
So it's the gun, so the gun part of this, is that the distinction that you're making?
No, and I think we tried to make that clear in the brief, that it's not necessarily, this case is not about guns. This case is not does not necessarily provide this court for some watershed event to talk about the nature of guns and gun violence. That was just what happened to be the mechanism in this case. But when I say, I do break it into two prongs, as I start with, no, they didn't know anyone was armed at the party. And then they didn't know that there was violence that was impending or imminent. And that second part wraps up that first part. And I think that it's just the nature of the harm that could be had by a gun that makes it actually another avenue through which there perhaps would have been a duty if they were invitees. In other words, if somebody has a glass bottle in the party. That doesn't give rise to a duty that that person is going to, hit somebody over the side of the head with it. But if there's someone who's brandishing a firearm, I think that may be an indication that violence was impending or imminent.
Mr. Dietrich?
Yes.
Does a licensee become an invitee if the property owner allows the licensee to stay on the premises, stays with the licensee on the premises, and allows the licensee to do whatever the licensee wants to do?
No, Your Honor. I mean, not in this case, and not generally. I think there's a line in one of the restatements, a comment to one of the restatements that talks about a person is a bear licensee when they allow the boys of the town to play soccer on a field, where it's somebody who's, and it has echoes sort of the recreational use statute, but it's where somebody acquiesces or gives permission for somebody to come into their property, but they don't necessarily induce them to do so. And I think in that comment it talks about if the person erected a playground, that to induce children to come and play on that playground, and those children might be invitees. But if the landowner just sort of sits back and says, oh, there's some boys playing soccer or baseball on my empty lot, the relationship between those boys and the landowner is one of a bear licensee as opposed to invitee.
Are you familiar with the state-created theory of liability? It hasn't come up in this case. It's a theory of liability. It's unlike the public duty liability. I wrote about this in a dissent in the Nugent case, where the state creates or exposes an individual to a risk that the individual wouldn't otherwise face, and then the state behaves deliberately indifferently after the person is exposed to this danger. And the facts of this case cause me to wonder if this doctrine or theory of state-created liability might have some applicability here. So as first, are you familiar with this theory?
As a subset of the public duty doctrine, or as discussed in those cases, yes.
And would you be familiar enough to comment on its potential applicability to these circumstances?
Well, one, I think that as a subset of the public duty doctrine, it is a very high standard. And even in those cases where I believe the circumstances were where a police officer arrests someone for DUI, they let that person, they say, don't drive, go home, and that person ends up getting back in their car and driving, that even in those circumstances, that there was not, that it didn't give rise to that type of duty. There's a very high burden that has to be created, even in the Joseph Cammarata cases and the 911 cases where they give wrong information and people are relying on the police when they call 911 to then rescue them or go to particular locations. And when there are mistakes that are made, the public duty doctrine doesn't kick in or does kick in to protect those people because it's all about the discretion and all about how we attribute liability.
And I agree, the facts of this case aren't on all fours, and rarely is that the circumstance when we examine case law and the case that's before us or the court. But this is a situation where police officers, the campus police department, was undoubtedly aware of this large gathering, the potential for increasing danger, and stood by and did nothing. It could be argued acted with deliberate indifference, which is part of the standard of the state-created theory of liability. And so,
but I think the dividing line, as it always is, or as always has been in this case, is was there any indication of impending violence? And that could be shown through a fist fight developing or the brandishing of a firearm. And where there isn't that case, then I don't think any of that kicks in. They were standing by because they were monitoring that party. They weren't sort of laughing and how let's see what happens. It was they were saying let's see what's happening, but they were doing that so that they could respond.
Wasn't there a recommendation to contact the County Police Department that they turned down or didn't act on. So there seems to have been indications that greater police involvement could have been warranted for this gathering that were ignored. And I know this state-created theory of liability hasn't been briefed yet, but the circumstances really cause me to question whether it might have some applicability here.
But, well, for one, I think that's why we briefed in the later part of our brief something about the public duty doctrine, because I think when
This
these,
is different than the public duty doctrine, which has been defined by case law to run to individuals. This is different. I'm not talking about that type of duty.
I understand, I think it's in the same universe. But what it invokes is in the same universe, which is what we give police officers discretion to take action or not take action depending on their professional training. Because, you know, we talk about we needed to intervene here. Well, what if the cure is worse than the disease? If these individuals are having this party, they're having a good time, there's no indication of violence, and then all of a sudden the police move in or even place themselves to instigate people who might leave, and there might be trampling, there might be a rush to leave, there might be fights in that rush to leave, there might be chaos, the individuals may spread through campus. There's all these sorts of things that we let the police do what they do because we don't know what's going to happen and there may not be right answers in all cases.
For all we know, the crowd may not have even gathered and increased in numbers had there not been visible police officers and the people feeling protected.
But I think also affecting this discretion is the fact that, and it's in the complaint, is that 4 days earlier, a similar pop-up party occurred. And that pop-up party dissolved without violence or incident. And so the police had an anchor in that to say, hey, maybe if we just let this go, it'll go without incident, just like it was 3 or 4 days ago. And people have a right to assemble,
And what you're saying is that they allowed the circumstance, they made the decision to allow the circumstance to go. And that's the first step in determining whether there's a state-created basis of liability, that they make a decision to let a situation occur, to expose individuals to a danger that they otherwise would not have been exposed to.
But, and I see where you're going, but I think the pushback is what danger? The danger did not exist 3 days earlier. The party dissolved without incident. Up to the point where someone was shot, there was no indication that there was violence that was imminent or impending. And so that's the perspective that the police have, is that they have this calculus of what should we do, if anything. And they're monitoring the party, they're making sure that they're there if anything happens. They have that option to call Baltimore County Police Department, but they didn't think that it was necessary. And that's in their discretion, and that's part of that universe of the public duty doctrine that's invoked in this case, or implicated in this case.
So, Dietrich, let me ask you a question. Let's say, think of a far-fetched hypothetical. Say Maryland wins the Big Ten championship and football game, and you know, the folks in College Park is very excited on campus. There's a small crowd, leak gets to a bigger crowd. People start drinking, it becomes rowdy. They're singing the Turf fight song, and you know, violence occurs and someone gets shot. Police are watching it, they're concerned, they do nothing. And if someone gets shot, is it your position that the university has no, because it's unanticipated that there's a shooting, that the university has no duty to protect those folks?
Well,
The revelers at the Maryland Big Ten football championship celebration?
well,
Pop
I
up?
wouldn't want to necessarily push back on your hypothetical, but in that
Which
case,
part, about winning Big Ten, or?
I think it's possible. I still believe, but if that happens, it would be anticipated based on past events and past behavior of students that people would come, and I think onto campus and would go to the stadium or wherever they're going to go.
There
And
might be more than 400 people at that event.
maybe more than 400 people at that event, but they would, I think, be prepared. But it's also does kind of invoke this situation where people show up, they are not necessarily invited to do so, there's no accommodation made for them, and now you're placing the university in the position of, what do we do for something that we didn't, from the outset, have control over? And I hate to bring it back to the cases, but that's what's implicated in the cases with invitees, is where you have a bar. You invite people. You know what your capacity is. You know you're gonna have ladies' night on Tuesday, which attracts 100 people, and therefore you get the security that's there. And if you don't have the security for places where you invite people, then that's a problematic thing when injuries occur. Or if you're a business, you have security, or if you're these places that invite people, or if it's the university having a football game or a basketball game or an art show or a play or anything, they invite people and they make accommodations for a known event. It's like, look at the safe management case out of the appellate court, which involved the celebration at the Ravens Stadium. What that's based on fundamentally was a miscalculation of how many people were going to come to that celebration, and therefore a miscalculation of how many personnel, security personnel, were there. But that's based on the idea that we invited people to come to the stadium for that event, and we should have been, or the stadium, the Ravens and the Stadium Authority and the defendants in that case should have made plans for what they knew was going to happen, and they didn't, and that's why they were on
What about the circumstance? I can think of a whole lot of other circumstances, and again, we're talking about a duty as a matter of law to protect people from gun violence. What about a fraternity party? Fraternity parties happen on campus all the time. On a lot of college campuses, they're not sanctioned, but the university knows about them. They're happening in basements. If we recognize a duty of this nature, and I can see where it is foreseeable somebody could get pushed or shoved or drink too much at a fraternity party, but what is a university's obligation to protect students from gun violence at a fraternity party that's likely sanctioned because they know about it, they turn a blind eye? Probably it is part of the promotional materials that it's a party school.
A few responses. One is that the fraternity would be sort of liable. They would be responsible as the sanctioning party to have that, and if something happens, then arguably they would be responsible in tort for any injuries. But also, one thing that is not present in this case, in fact, affirmatively not present in this case, is knowledge of prior incidences. So I would think that if there's fraternity parties, if a particular fraternity has particularly rowdy parties and people get sick or injured, or there are bad things happening, and the university lays a blind eye to that, and then something happens at that party, at a future party, there might be liability based on the notion that I believe the first or second coronality scenario, where you know that stuff's going to happen. I think it's the first. You know that stuff's going to happen, and you just sat back and just let it happen, even though you anticipated it based on prior incidences. Here, that's not the case, because we affirmatively have a party that didn't result in that.
But there is, sadly, there's been a lot of documented instances of gun violence on campuses, both during daytime and nighttime hours, nationally, for sure. I don't have the statistics handy, but it's a known phenomenon. Does that come into play? There's no doubt, at least as alleged, the police were concerned about this. And as it turns out, sadly, they had reason to be concerned that particular time. But it seems like you're asking us to look at this just through a very narrow lens of there wasn't prior violence last week or on this particular campus, but there's a reason these police officers are concerned.
Well, I understand that. I think there's two aspects of gun violence at play. One, just let me this is not a case about like an Aurora style or a Las Vegas style random shooting. And in fact, even though that's invoked in opposing counsel's briefing, because this case is about, as they frame it, a sort of bubbling up and boiling point that sort of explodes, and that's not what we think of when we think of a mass shooting like the one at the Dark Knight or in Las Vegas. But with regard to gun violence generally, I think that, again, we don't necessarily contest that that is a form of violence that we need to be on the lookout for. But when there are no indications of that form of violence, then no duty arises.
Well, shouldn't they be prepared? I mean, aren't the Towson State University police officers armed?
They are. I mean, they're prepared for all types of violence.
And foreseeability doesn't depend on there having been a prior incident like what occurs in order to put someone or party on notice. It's a much more fluid concept which involves whatever is likely to occur that a reasonable person might anticipate. Wouldn't it be reasonable for police officers to anticipate a large crowd gathering in the middle of the campus with the music, the cannabis, the other features? There's an element of danger.
There could be, but there were no indications. You know, just those allegations by themselves, they're hinting at something. And I get that, but they don't, in the absence of any indication of violence or impending violence, there was no reasonable foreseeability. There's the possibility, but the possibility is not enough. It needs to be the reasonable probability and foreseeability.
But you're taking such a narrow definition of reasonable foreseeability, limiting it to there having to be prior knowledge or reason to expect the very specific act that occurs. And I'm suggesting that it's a broader definition of what a reasonable, in this instance, officer might foresee. And based on our very real world knowledge of violence, prevalence of guns, that this was a reasonably foreseeable event.
But again, I just want to push back. The idea that this case is special because it has gun violence, I would push back on that. There was no indication of any violence. And especially there was no indication that anyone was armed. If the police got wind that someone was brandishing a firearm, and I know we have to be careful because of the Second Amendment, but if somebody was brandishing a firearm, that might be enough to give rise to that duty. But in the absence of those...
Mr. Dixon, I'm going to push back a little. Under your theory, then, police officers would never provide crowd control unless they had some belief that somebody there might be armed or there had been a prior incident. They'd never bother about crowd control.
I don't say they would never bother because they have, you know, we're talking about a tort duty here, and they may have a moral duty and they may have a professional duty, but the professional duty is not something that's actionable. I think that's what opposing counsel hinted at with going into the aftermath and the sort of Monday morning quarterbacking of what happened in this incident, is that was based on their professional duty, and that's a different thing that we can't hold them accountable in tort for.
Doesn't that go to breach? I mean, it seems to me you're making exactly the argument that Segerman prohibits, and that is the particular kind of harm. That because this isn't a particular kind of harm that the police, you know, couldn't predict, therefore there's no duty. But that's what Segerman says. No, you're not supposed to look at that. You're supposed to look at, you know, the you look at the entire circumstances of the situation. You know, the exact type of harm we can't predict. But something bad is going to happen at a pop-up party with 400 kids that we know about, and they're drinking and smoking.
But I think it could be foreseen, a bunch of kids doing calisthenics in a classroom, that somebody is going to maybe kick another kid.
Or rape, like, or, you know, one of the examples counsel brought up. I mean, there's a lot of measures of harm. It seems to me that it's a very narrow view you're taking. You're doing exactly the thing that Segerman says we can't do. We're looking at the particular type of harm. I mean, it may very well be that it's not a breach. I mean, I don't know. I mean, later on, if we go through discovery and find out all the facts, there may not be a breach. Maybe there's a duty and the university didn't breach it. That's fine, but on this status, to say we can't predict this particular type of harm, so therefore there's no duty.
And I know my time's up. May I make one last comment? And that's why I think it's inappropriate to look at those cases that involve school children, which are clearly invitees or some form of that, to inform the analysis in this case. Thank you, Your Honor.
Just one quick question.
Yes.
Would your argument, if there was an indication of a pushing or shoving or some sort of altercation, would that change your view? In other words, is your analysis focused on the foreseeability of somebody opening gunfire or just violence in general?
I think if they are invitees and they see a physical argument developing, then they would have a responsibility to intervene.
Okay, so it's not just focused on the possibility, foreseeability of somebody opening gunfire?
Correct.
Okay.
Thank you.
Okay, I don't see any other questions, so thank you, Mr. Dietrich. Mr. Cammarata, you'll have just over 8 minutes reserved for rebuttal.
Yes, Your Honor, thank you very much. Let me just start where counsel just ended. They didn't see it. Well, that's not the standard, as Your Honor has mentioned. The standard is is it likely? If you look at the Ruddy case, it talks about all that can be required is knowledge or means of knowledge of such disorderly or reckless conduct as is likely to result in injury in some manner to others. And then you get the Seligman case that credits McLeod, the rape of the child. Is it within the harm within the general field of danger? And here it is. Did they have some of the points? They had control over this party, or they could have exercised control. The university president and the chief of police said, don't stand down. So they had a conscious decision, that's what we're gonna do. But two of the police officers said, we gotta act. And then what did the university do when the violence happened and they sorted it out? They agree with us. They agree with Ms. Torney because they suspended the police corporal for, among other things, not reaching out to Baltimore County that was on call for assistance, and number two, for her failure to act.
Isn't that really just because of the failure to follow the protocol in place? How does that make it a breach of a tort duty?
Yes, Your Honor. Yes, only insofar as this. There was an element of her suspension, and it's in one of the allegations of the complaint, that led to her being suspended because one reason was because she failed to do the required notifications.
I have no issue with what that record shows. I'm trying to figure out where the connection is then to a tort duty, a breach of a tort duty.
They recognized they had a duty and she failed to act. And they gave her...
They weren't the ones they're not the ones to decide she owed a duty and breached that duty to Ms. Torney. They said, here's our protocol that when we have these sorts of mass gatherings, unsanctioned, we want our security team to contact Baltimore County. She didn't do that, and she's suspended. But they're not making a determination as to a tort duty, are they?
No, they're not. No, I'm not suggesting
How are
that they
you
are.
using that to connect it to a tort duty here?
It credits our position. We allege that their requirements were in accordance with the standard of care for reasonable conduct relative to a situation such as this. And therefore, it's evidence of their own finding that this was something that was not the appropriate way. Now, whether or not, I'm just using it as an evidentiary point. And I do think that on this record, we should be permitted to go forward. And the university will have this chance later to file a motion for summary judgment once the record is fully developed. But they want to debate facts. They want to debate, well, we had a prior pop-up party and nothing happened. Okay, that nothing happened. But what were the circumstances? Were there 5 people, 10 people? Was there music? Was there underage drinking? We have to assume that it was facts and that create the inferences of those facts, take the inferences of those facts that favor Ms. Torney. You can't adopt what counsel wants because he's adopting facts that are contrary.
I think it's just, it's the complaint that references the prior party, right?
Yes.
So that's just taking the facts in the complaint.
Well, drawing an inference. Oh, well, it was another part. He's expanding it to include facts. Yes, Your Honor.
I'm sorry, well, what inference are we to draw from the fact that there was a prior party with no incident?
There was a prior party, and they knew about it. They stood down, and they acquiesced in it. Then they acquiesced in it now. That's it. Not that it was a prior party and it was orderly and the police used discretion and all that sort of stuff. That's not it. I want to just cover a couple other things. I think that in terms of the issue of bare licensee versus invitee, that is precluded based on the court's rules 8-131A, 8-131B1 as well. With respect to the public duty doctrine, this has gotten mixed up by counsel. The public duty doctrine doesn't apply here. Why? Because this is not a claim against the sovereign, and we're arguing that the police owed a general duty to the public, of which he was a member of the public. This duty that we're talking about is the duty that a landowner owes to an invitee. They used agents, campus police. They could have used anybody that they wanted. They used campus police to fulfill their duty, and they didn't do a very good job. And that's why we're here. It's got nothing to do with the public duty doctrine. A frat party, Your Honor, a frat party, I think, falls within the case, I think it's Rainey or something like that, where a student was injured inside a dorm room. And the court said, well, that's different because it's not in a common area. Frat party is a different beast, I would submit. And here we are in a common area. They had a duty to look and see what there is to be seen, what their officers recognized as was required to do, that a DJ recognized what was required to do. Shut the party down. He's trying to restore order. Does he get any help from anybody? No. Should he have gotten help? Yes. Do we have to know that a gun was going to be used? No. Was it within the general field of danger that she was going to be harmed under the facts of this case? Yes. Does it matter the mechanism? No. Does it matter the instrumentality? No. And therefore, this case should proceed to allow Ms. Torney to develop the facts, to show in a much broader detail why the university failed in its duty as a landowner to an invitee to protect the landowner from harm that was within the general field of danger. And it doesn't matter that it was a gun, but it should matter to this body that a gun should not be exempt from the type of harm that we should protect our citizens against. The use of guns is rampant in society, and it's about time that our law caught up with it, that we're not going to turn a blind eye because it was a gun instead of a stick or a fist or a bottle, and we're going to give it a pass. No. Now's the time that this court can take up this very important issue, and I'm glad, and I thank you for this time and the opportunity to take it up and to think about it. And I do think it is important to let people understand. You can't just sit with your hands in your pockets and, shucks, we'll just, Chief told us just to stand by, stand down. No, that's not the way it works. And if you stand there, you got to do something there and see what there is to be seen. And if you had presence, you would have changed the outcome. Thank you all very much.
Thank you, Mr. Cammarata. Thank you both for your arguments. Case 53.